My name is Jordan Yeager, and I'm an attorney with the law firm of Curtin & Kiefner, and I am attorney for Delaware Riverkeeper Network, and I am going to talk today about Pennsylvania's Environmental Rights Amendment in practice, and going to spend some time going through cases at the Pennsylvania Supreme Court, the Pennsylvania Commonwealth Court, and at the State Environmental Hearing Board to look at how the courts have been applying Pennsylvania's Green Amendment, which I'll refer to as the Environmental Rights Amendment, sometimes as Section 27, how they've been applying it to help protect communities from environmental harm, and what the path into the future looks like along those lines. So we start with really where the Environmental Rights Amendment in Pennsylvania first got meaning, which was a case that I was involved in on behalf of the Delaware Riverkeeper Network and a group of communities around the state, and it's known as the Robinson Township Delaware Riverkeeper Network case, and it was in the Pennsylvania Supreme Court initially with a decision that came out in December of 2013. And this was the first instance of a Pennsylvania court striking down a law because it violated the environmental rights of Pennsylvania residents and relied on arguments that we made on behalf of the Delaware Riverkeeper Network, and a case that really gave life to Pennsylvania's Green Amendment. It came about because the Pennsylvania General Assembly, our legislature here, and Governor Corbett at the time, enacted a law known as Act 13 that took away local zoning authority over fracking and related infrastructure. It did a lot of other things that put people at risk, including putting a gag order on physicians from disclosing information about exposure to fracking chemicals, granted eminent domain authority to the drilling industry for gas storage, limited notifications regarding contaminations of private drinking water wells, and provided automatic waivers for what were themselves very minimal environmental protection standards. So Act 13 would have allowed a lot of communities to be exposed to very significant harm, principally through the elimination of local zoning authority over fracking and related infrastructure. We argued that that law violated the Environmental Rights Amendment, and the Supreme Court agreed. So it was really the first time that we were successful in getting what would have been a really powerfully bad law blocked, and we wouldn't have been able to do that but for the Environmental Rights Amendment in Pennsylvania's Constitution. The next case to come along was the Pennsylvania Supreme Court decision in 2017 involving the Pennsylvania Environmental Defense Foundation, also known as PEDF. And there are a lot of different elements to the case, but at its core, it involved challenges to the state's leasing of state land for fracking and the taking of the royalties from that leasing program and putting it into the state general fund rather than back into the protection and preservation of Pennsylvania's natural resources. And the Pennsylvania Supreme Court in that case ruled that the sale of those public natural resources, that those are part of the trust, part of the body of the trust that are held to the benefit, it's supposed to be held to the benefit of the people of Pennsylvania. And that meant that the Commonwealth has to manage those resources consistent with its duties as a trustee, and that by diverting them to non-trust purposes, taking them out of the protection of natural resources, constitutes a violation of that trust obligation. So it was a significant case in the result in making it clear that the legislature violates the Environmental Rights Amendment when it takes proceeds from the natural resources and moves them out of those purposes. It also was important because the PEDF case was also important because it was a majority of the Pennsylvania Supreme Court adopting the rationale and the standards that had been discussed by a plurality of the Supreme Court in the Act 13 litigation, the Robinson Township Delaware Riverkeeper network litigation from 2013. So I want to go through and spend a little bit of time talking about kind of the key principles from the Supreme Court's decisions in these two environmental rights amendment cases. And there are a variety of quotes over the next couple pages. And these are quotes that are generally from the Act 13 case that were then restated by the court in the PEDF case. And so the first significant understanding to come out of these two Pennsylvania Supreme Court decisions is that environmental rights are on par, that they're equal to the people's other political rights, and that the government is limited by these constitutional provisions, and that these are fundamental rights that are reserved to the people, just like the other provisions in Pennsylvania's Declaration of Rights, which is kind of the equivalent of what other states might call their Bill of Rights, or what we call the Bill of Rights in the federal Constitution. And as with all constitutional provisions, the basic starting point for analysis always has to lie with the text of the Constitution itself. Pennsylvania's Environmental Rights Amendment also has trust language, and the court said that we look to Pennsylvania trust law that was in effect at the time of the Environmental Rights Amendment enactment, which was in 1971. Then looking at the specific language of Pennsylvania's Environmental Rights Amendment, the court has made it clear that that first sentence, which is a right to clean air, pure water, and a healthy environment, that is a prohibition that declares the rights of the citizens, and it places limitations on the state's power to act contrary to those rights, so that any law that unreasonably impairs those rights is unconstitutional. The second right stated in Section 27 in Pennsylvania's Green Amendment is that the public natural resources of Pennsylvania are owned in common ownership by the people, including future generations. And the courts have looked at that phrase, public natural resources, and looked at it in a broad way. And the court has made it clear that it isn't simply limited to property that is owned by the government, but any natural resources that involve a public interest. So, for example, the air and the water aren't owned by the state government, but we're all dependent on them, and so there's a public interest that attaches them, and those are part of what are protected. The health and the cleanliness of those resources are part of what's protected by the Environmental Rights Amendment. The Pennsylvania Environmental Rights Amendment establishes a public trust, puts the government in the position of trustee, and all the people are the beneficiaries of that trust. The duties as trustee are not limited to just the state government. They're not limited to just the Pennsylvania Department of Environmental Protection, but those trust obligations have to be carried out by all state agencies, all entities of the Commonwealth government, including all political subdivisions, all local governments, and all local agencies. So that means that a township board of supervisors, or a township zoning hearing board, or a borough council, or a local municipal authority all have to respect the environmental rights of residents, just like the state government does. The two key elements then of those trust obligations are to prohibit the degradation, diminution, and depletion of our natural resources, whether that is from direct state action or from the actions of private parties, and to act affirmatively via legislation to protect the environment. The fiduciary duties means that you have to act reasonably, and the limits on that authority is to conserve and maintain those natural resources that are held in common ownership by the people. The trust duties that apply here are the trust duties that would apply in any circumstance where you have a trust that's been created. So the trustee has to act with prudence, loyalty, and impartiality. I want to look now at some of the intermediate court decisions in Pennsylvania. The principal intermediate appellate court in Pennsylvania that hears cases involving environmental rights is the Pennsylvania Commonwealth Court. Now, some of these cases are in the Act 13 case, in the PEDF case, we saw very clear positive outcomes for the people because of the arguments under the Environmental Rights Amendment. In some of these cases, the results of the individual cases didn't stop bad stuff from happening, but they established very clear standards that will guide government decision makers into the future. So I think they're worth exploring because it's only been a few years now since the establishment of this case law has really started to grow. And so the standards that are discussed in these cases, even when they don't lead to a clear positive result for the litigants in those individual cases, provide important litigation tools and advocacy tools for people down the road and will help limit harm from being done in the future. One of the ways that, one of the ways that these issues come up is similar to an issue that was raised in the Act 13 litigation, which is when you have the state trying to preempt local regulation. And preemption is basically a legal term for the ability of a higher branch of government to trump what a lower branch of government does and to prevent that lower branch of government from regulating in a certain area. And that was effectively what was being tried in Act 13. It was an effort by the state to say any area of environmental regulation as it relates to unconventional natural gas development is going to be limited by what's done at the state level, and no local government can enact regulations that would go further than what the state has done. And the Supreme Court in the Act 13 litigation struck that broad preemption down. That and so in this UGI Utilities case, the Commonwealth Court recognized in February of 2018 that the Environmental Rights Amendment can prevent the state from preempting local regulation where that state statute or regulation completely removes environmental protections that it violates the state's duties under that constitutional provision. So while not all efforts at the state level to preempt local regulations are going to be unconstitutional, if they completely remove environmental protections and violate the constitutional obligations under the Environmental Rights Amendment, then they're going to be vulnerable going forward. Another case involving the Delaware Riverkeeper network was decided in July of 2018, and this implicates the state's affirmative duty to take action. So not simply whereas the state, a lot of the cases come up in the context of state's done something wrong and the citizens and an environmental group will say, state, you shouldn't have allowed that, you shouldn't have done that thing which caused something bad to happen. This is a situation where the state didn't act and the claim was, state, you have a duty to act under the Environmental Rights Amendment. And in this Delaware Riverkeeper Network versus DEP case, the Commonwealth Court agreed that you can bring a claim under the Environmental Rights Amendment to order the state to act when it hasn't acted. And this is a case involving a contaminated site in southeastern PA known as the Bishop Tube site. And DEP acknowledged having a mandatory duty to prevent degradation, but the court went further and made it clear that DEP can be ordered to act when chronic inaction infringes on protected environmental rights. And in that case, the state had acknowledged that there was contamination. The state had acknowledged that unless immediate action was taken, that additional harm would be done, and yet the state failed to take that follow-up action. In fact, allowed things to sit for well over a decade. So a very significant decision in requiring DEP to take action. Another case now we're going to move into a set of cases from the Pennsylvania Environmental Hearing Board. Pennsylvania Environmental Hearing Board is the court that hears appeals from the Department of Environmental Protection's permitting decisions. So anytime Department of Environmental Protection takes an action, there is an ability to appeal that to the Environmental Hearing Board. In the Brockway Borough Municipal Authority case, there was a challenge to the issuance of a permit of a fracking well on a water authority's property. And the Environmental Hearing Board made it clear that the constitutional protections under the Pennsylvania Constitution's Environmental Rights Amendment require more than simple compliance with the applicable statutes and regulations. And that simply, and this is a running theme that we'll see throughout the Environmental Hearing Board cases that we're going to discuss, that simply because you're complying with the statutes and regulations doesn't mean you're necessarily complying with the higher standards under the Constitution. And so if we look at regulations and statutes and constitutional provisions in a hierarchy, you have regulations at the bottom, statutes in between, and Constitution at the top. And so when the state or local government is taking action, they have to comply with all of them. And simply because you've complied with one level doesn't mean you complied with another level. And so this is a significant advance in having those constitutional protections. It means that there's a backstop against bad action that might otherwise be able to be done because the developer or industry can say that they've complied with the more narrow restrictions of the statutes or the regulations. In the Tri-County landfill case, it's a situation where there was a landfill that had appealed from a DEP permitting decision where the DEP had looked at the landfill's failure to comply with local zoning. And the Environmental Hearing Board in the Tri-County case made it clear that one of the ways that local governments meet their constitutional duties is through zoning ordinances. And so the DEP is justified in denying a permit if what's being proposed would not comply with those local zoning ordinances. And so it recognizes the local element to environmental protection and to permitting decisions. And those permitting decisions can then be challenged whether they're issued at the state level or issued at the local level. Sludge-free Upper Mount, UMBT stands for Upper Mount Bethel Township. This is another case that the Delaware Riverkeeper Network was involved in at the Environmental Hearing Board, and it was a challenge to the Department of Environmental Protection's approval of a proposal to spread sewage sludge on three farms across a number of different fields in Northampton County. And the companies had sought to have the appeals thrown out, and the Environmental Hearing Board refused to do that and allowed the cases to proceed. And in doing so, the Environmental Hearing Board again made it clear that under the Environmental Rights Amendment, strict compliance with all regulatory requirements is not necessarily the same thing as meeting your constitutional obligations to reduce environmental harm to a minimum. The case also, and this was before the PEDF decision was issued, but the case also made it clear that compliance with the regulatory requirements was not enough, and that an appeal could be successful if the environmental harms that remain outweigh the benefits of the project. Again, even though the applicant, the company that wanted to spread the sewage sludge, even though they had met the regulatory requirements. Ultimately, in that case, the case was successful, and the company withdrew its application, and the DEP withdrew its approvals. So the Environmental Rights Amendment played a significant role there in protecting the residents in the area where the sewage sludge was proposed, and in protecting the tributaries that flowed into the Delaware River in that location, and the groundwater supplies that the folks there relied on. Another case at the Environmental Hearing Board where the Environmental Rights Amendment played a significant role is a case known as Hudson versus DEP from 2015. This is a case involving a CAFO, which is a large industrial hog breeding facility, and the Department of Environmental Protection had approved stormwater management permit for this project, and the Environmental Hearing Board put a hold on that permit and said that the project couldn't move forward during the pendency of the appeal because the permittee, the company that wanted to install this industrial hog facility, hadn't provided data to show that the design was going to function properly and protect the environment. And the case stands for the proposition that had also been stated in the Supreme Court that as part of the trustee obligations, the Department of Environmental Protection has to consider the environmental effects of an action prior to acting. And so, in effect, what the board said, and what they actually said, was you can't approve an experiment. And the way we talk about this concept under the Environmental Rights Amendment is that it really requires science-based decision-making. And unless the people who are making the permit decisions have sufficient information to determine that the project can be carried out in a way that will protect the environmental rights of the residents and that will prevent the unreasonable degradation of the natural resources, the project can't be allowed to go forward. And so it's not simply you got to study it before you decide, but if that study tells you that that it can't be done in an adequately protective way, then the project can't go forward. And in fact, with this Hudson project, although the stay was put in place in 2015, the project still has not moved forward. Snyder versus DEP is another 2015 Environmental Hearing Board case involving an air quality plan for a natural gas compressor station. And there again, the Environmental Hearing Board denied the compressor station company's effort to try to have the appeal dismissed, and in doing so made it clear again that the department has an obligation to consider local land use requirements, and that compliance with the Environmental Rights Amendment can require more than simple compliance with the statutes and regs. So because of those Environmental Rights Amendment claims, the appeal of that compressor station was allowed to proceed. National Fuel Gas Corporation versus DEP, another Environmental Hearing Board case from 2015. The Environmental Hearing Board, Judge Labuscus, issued a concurring opinion making it clear that in order to carry out your trust obligations and in order to do that science-based decision-making, it's not enough to simply consider what's going on the individual site, but you also have to consider the context of other nearby sources, and you have to consider the cumulative impact, the cumulative adverse impacts that those other polluting sources will have on people's right to clean air and the preservation of the natural, scenic, historic, and aesthetic values of the environment. So we see in the Environmental Rights Amendment in practice in Pennsylvania a broadening beyond simply looking at the individual impact of a site, but really seriously looking at the cumulative impacts on the environment of the projects that are being proposed in an area and being carried out in an area. And in that case, too, following that decision from the Environmental Hearing Board, the company ultimately withdrew its appeal of the DEP limitations on its permit. Friends of Lackawanna versus Department of Environmental Protection, we have two cases that we're going to look at from that litigation. This involved DEP's approval of a renewal permit for a very large landfill in Lackawanna County outside of Scranton, 714-acre landfill. And the Environmental Hearing Board again made it clear that the department and the board have a constitutional duty to consider the extent and nature of impacts even if it would otherwise be permitted under the statute and regs. So not only are we going to look beyond the statute and regs, but here the board inserted into that the duty, the constitutional duty, to genuinely consider what will happen if this project's allowed to move forward. A significant environmental victory was in the Center for Coalfield Justice case, a 2017 decision from the Environmental Hearing Board, and this involved longwell coal mining of a panel near the Ryerson Station State Park, and the longwell mining permit that was approved there was going to so undermine the area that it was really destroying the stream in that area. And what DEP was proposing to allow the mining company to do was to destroy the stream and then rebuild it, effectively eliminating the stream as it had previously existed, and to create simply a constructed replacement stream, not as it had existed in the natural environment. And DEP said, the Environmental Hearing Board said, no, DEP, you can't approve that kind of destruction of the environment. And there, as in each of these cases, both the company and DEP, their defense had been, well, it meets the standards under the statutes and regs. The Environmental Hearing Board said, no, first of all, streams are public natural resources under the Environmental Rights Amendment, and therefore protected, and that statutory and regulatory compliance doesn't mean that you've met the constitutional standards. And so the Environmental Hearing Board was able to undo what would have been really devastating continued damage to this area, and did so in reliance on the Environmental Rights Amendment. Back to a later adjudication in the Friends of Lackawanna case, and there one of the issues that industry advocates have raised is to say that private property, that what goes on in private property is simply within the rights of the property owner, and that the Environmental Rights Amendment doesn't touch on what goes on an individual's private property, that it should only be applied when public property is directly impacted. The Environmental Hearing Board rejected that argument and agreed that the state cannot allow the use of private property that will impermissibly infringe on the constitutional rights of others. So at its core, there's a recognition that the folks who live nearby have rights too. And if what you're doing on your land is going to take away and injure the rights of people who live nearby, then you can't do it. In the Clean Air Council Delaware Riverkeeper Network versus DEP case from January of 2018, this was a case involving challenges to erosion and sedimentation permits and water encroachment permits for the Sunoco Mariner East 2 pipeline project. While the board allowed the project to go forward, the board also made it clear that there is a constitutional duty to fully consider the environmental effects of any proposed action in advance of proceeding. And that's obviously, as I indicated before, one of the key things that has come out of these court decisions and Environmental Hearing Board decisions since 2013, since the Act 13 decision, that provides significant tools for advocates going forward when there has been a hasty rush to judgment to allow bad projects to move forward. And so that wraps up these discussion points for now. All of this is a reminder on the importance of having a green amendment, and a reminder that having a green amendment in place will help prevent bad projects from moving forward and add an added layer of protection beyond what are often inadequate statutes and regulations, and it elevates the protection of our environment to the highest level and puts it on a plane with our other core fundamental rights, like our free speech rights and those other rights that have been protected for centuries.